Good morning, everyone. It's 11:05 and we'll start. I'm not sure there's any other people outside. Could someone shut the doors for me? Thanks. My name is Richard Leaning. I'm from the RIPE NCC, which is the Regional Internet Registry for Europe, all the way up to Russia and down to the Middle East. And we look after the IP addresses. And I'm the moderator today, and my co-moderator is Nina Elsa here from Centre. And the session, Workshop 4, is on criminal justice. So just to give you a bit of background, and I'm sorry if I'm walking around, but I can't see anyone because that light is right in my eyes. That's better. I'm over here now. Today's session is going to basically be on the challenges that law enforcement in particular have when they're investigating criminal offences that have a presence on the internet. And I phrase it that way because cybercrime, as we all hear, is not just what law enforcement need e-evidence for. All crime, from theft of bicycles, theft of cars, burglary, murders, rapes, terrorist offences, etc., all have a presence on the internet. And therefore, criminal justice, for it to proceed, needs law enforcement's ability to gather e-evidence, evidence that's on the internet that will help them in their investigations in criminal offences. So that's just the background of it. So it's not cybercrime, so please get that out of your heads. It's all crime has a presence on the internet. So in the panel today, we have Greg Meunier, who's from the Europol, the European Cybercrime Centre. Constantine Samaras, who's from ISOC, Christian Borgreen, who's from the CCIA, and Catherine Bauer-Boos from DG Home, who's the Deputy Head of the Cyber Crime Unit there. So we'll start with Greg, who's going to talk about things called carrier grade NAT, and hopefully Greg, in layman's terms, will explain what a carrier grade NAT. But it's basically one of the challenges that law enforcement have where you have 1,000 people sharing one IP address at one time. And the challenges that proposes for law enforcement, then we'll build the conversation up from there. So we'll start with Greg, please.
Good morning, everyone. Thank you very much, Dick, for the introduction. Thank you very much, Tanya, as well, for putting the panel together, and EuroDIG for inviting Europol to participate to this panel. So, challenges to investigate crime online. So, as Dick said, I'm representing the Europol, which is the European Police Agency, and I'm working for the Cyber Division. So we have many challenges to investigate crime online. And when we say crime online, it's really, as Dick said, any type of criminal activities that has that is using technology or has an access to the internet. So it doesn't have to be hardcore cybercrime, malware, WannaCry, and the rest. It can be, just an homicide, and somebody has a phone on it, on that person, and you need to track that person down, for instance, and you will face problems to investigate that crimes because of specific issues. So I'm just going to very briefly go through three main challenges, and then I spend a bit more time on the carrier grade network address translation, CGN, problem afterwards. So the first main problems, and I'll get it out of the way straight away, it's encryption. Encryption is great. It's sustaining our digital society. We need encryption for protecting privacy. We need strong encryptions for protecting our economy, for everything. It underpins our connected society. That's no problem. But of course, encryption is being misused, abused by individuals for criminal purposes. It is a fact that you have less and less warrant or requests for warrant from the police to the judges to wiretap phone nowadays, because most of the time criminals, be them terrorists, be them just drug trafficker, any types of criminals, will be using Signal, WhatsApp, any types of communication apps, just because it's more convenient, like you guys would do, they actually do it as well. Plus, it is encrypted, so we don't have access to the content. So that's an issue. As a society, I think we need to find a compromise. I don't have the silver bullet solution, but yes, it is one of the challenges that nowadays the law enforcement community, and I include the judiciary, has to investigate crime online. Another aspect is access to electronic evidence. In the past, when you would come a cop, if you come and investigate an homicide, for instance, you get on a crime scene and you would start gathering clues, evidence. So it can be a fingerprint, it can be footprint, it can be the weapon that has been used, maybe still lying on the floor. You will take a number of physical evidence in order to build your case and potentially identify a suspect and or dismiss that a suspect which might not have done anything. Even if it's a local crime, most of the evidence will be on the scene. Nowadays, even if you have a local crime, like somebody who gets onto a bank network and steals some money, it's a local bank, but most of your evidence will be stored somewhere on the server, not in your jurisdiction. So straight away, even if it's a local type of simple crime, you have to rely on heavy and cumbersome traditional justice cooperation instruments, international instruments, such as the Mutual Legal Assistance Treaty. And so there is a discrepancy between the type of crime you're investigating and the tools we have, which are very lengthy and very cumbersome. So that's another aspect. Of course, electronic evidence are very volatile. They can be deleted very quickly. They can be moved from one country to another very quickly. And so if you need to investigate quickly a type of crime, then you will have to rely on cumbersome and lengthy international tools. So that's another challenge. The third challenge I want to talk about is data retention. You're aware about a series of ruling that the European Court of Justice has given last year in terms of curtailing and limiting the rights and the obligations of the electronic service providers to log data. From a law enforcement perspective, I think it has to be made very, very clear that without historical data, you cannot investigate crimes related to the internet. You cannot. Of course, if you're investigating an organized crime, very well defined, then you can potentially look into the future and say, please log on all the information that is related to this and that devices, communication devices used by the group. But most of the time, when the police get a crime reported with a nexus to the internet, then you have to look in the past in order to be able to identify those people and who did the crime. So if you limit the data retention obligations too much, then you are unable to investigate crime online. That's really the message. Last but not least, I really want to spend a bit more time on carry-grade-NAT. Carry-grade-NAT is a technology which is massively being adopted by internet access providers. So what you might be saying ISPs, internet access providers, fixed line, mobile. This is related, of course, to something you know, which is the depletion of the pool of IPv4 addresses and the necessary transition to IPv6. In 2010, 2012, ISPs and internet access providers have started to adopt this transition mechanism to do the transitions. And 5 years later, we are in a situation where 90% of the mobile internet access providers, so if you use your phone in 4G to access the internet, this is behind a NAT. What does a NAT do? It is mutualizing IPv4 addresses. So you can have, potentially, in theory, you can have up to 65,000 users using exactly the same IP address, public IP address. Most of the time, if you are investigating a malicious IP and you go to internet access providers, they will give you a list of between hundreds and thousands users using exactly the same IP address at the same time. From a law enforcement perspective, this is a nightmare, of course, because we know that IP addresses are not the only identifiers, and it's not because you get the name or the device be connected to an IP address that you get your suspect. Of course, it's among a vast arrays of evidence then leads you through normal traditional police work to identify who is a suspect. But still, in 80% of your investigations, you will start with an IP address, you will start with an email address, and you need to get subscriber information, otherwise you can't start investigating. So we are in a situation now, 5 years later, 2017, where most of the internet access providers in the world are using carrier-grade NAT or large-scale NAT to mutualize IPv4 because they need to have dual stack, which is IPv4 plus IPv6 for each and every devices and servers so that you can go everywhere on the internet, even if you have traditional legacy devices that are only IPv4. The problem is that CGN has become a substitute for the transition to V6. That's a fact. Of course, V6 is growing very slowly, but not fast enough. And so what does that mean in terms of investigations? As I just said, if you have an IP address and you go to an internet service providers with a malicious IP, you get a huge list of potential suspects. So if it's let's say that somebody is selling an AK-47, and this is a proper case, on the public web, on an advertisement website, and that gets reported to the French police, because that's a French case recently. As an investigator, if you see that an AK-47 is being sold on the internet, you've got alarm bells ringing, because it's either because it might be used in Marseille for drug trafficking, violent hand or something between two rivals, or for a mass shooting in Paris. Over the last 2 years, that's the only times where AK-47 have been used. So if someone is selling an AK-47 on the internet, it might not be a huge offense, but the consequences might be super, super hard. So what you will do is you will get to that platforms and you say, please give me the log files of the person who posted that ad. You will get an IP address, probably a timestamp, and then you go to the internet access provider and you say, who's behind? And then they will tell you, and that's what happened, they will tell you, well, I can give you a list of 100 people that were using exactly the same IP address at the same time. What do? You drop the case, simple, because you don't have the resources to investigate everyone from such a case. But the consequences for other ongoing investigations in terrorism and drug trafficking might be really severe. I give you another example, child sexual abuse. This is also a recurring case that was given by the UK NCA. Somebody is uploading child abuse material on a platform. It's a UK address. The police request the IP address. We get the timestamp. We go back to the internet access providers. No, sorry, we have 50 or 100 users. What do? It means that if somebody is actually uploading new images on the platforms, it means that a kid is being violated and raped. That's what it means. So in the severity of that case, you will investigate every single people that are on that list. From a privacy perspective, this is a massive violation. So what I'm saying now is that CGN is pushing the judiciary and the law enforcement community to use privacy-invasive investigation methods, whereas if everyone was to be moving to IPv6 and phase out the use of CGN, then we would be able to find one potential suspect and do our normal work to dismiss the case or potentially prosecute. So I think I will probably end here, just to say that there are alternative solutions. In Belgium, for instance, the government, the police, and the federal prosecutor have sat together with the 4 Belgium-based ISPs, and they signed and they agreed on a voluntary agreement whereby they're limiting the number of people they're putting behind each IPv4 address, which means that on average, when the Belgian police requests the subscriber information of one person behind an IPv4 address, they get 4 suspects. In France, in Germany, they will probably get 50. So that's a massive difference in terms of investigation. So there are alternatives. We need a strong political will to push and solve that issue. Thank you.
Thanks very much, Greg. And I know Greg went on a bit longer than we normally have these type of panel sessions, but I think it was important to set the framework for this discussion, the challenges that law enforcement are having in this arena. I'm also conscious is that some of the technical people will use terminology not everyone in this audience will understand. So if there's something that someone has said that you don't understand, please wave at me and I'll get them to explain what it is, because otherwise we'll be going down technical jargon that only a few of us will ever understand. So now we're going to know what the challenges are. We'll have some of the other panelists say what is happening to try and lessen those challenges, try and help law enforcement do what they do. And now we're going to have Catherine from DG Home. Can you hear us, Catherine? Oh, yeah, she's on there. Wow.
Yes, hello everyone. I hope you can hear me.
Yes.
So yes, I'm Catherine Bauer-Bulst. I'm the Deputy Head of Unit for the Fight Against Cybercrime here at DG Home in the European Commission. And we've been doing a little work in particular on one of the issues that Greg has just introduced on access to electronic evidence. I think Greg made it very clear what the challenges are that law enforcement and the judiciary face in investigating cases nowadays that involve electronic evidence. And these challenges are compounded by the fact that many times the relevant information will not be located in the same jurisdiction as where the investigation is taking place. So just to build a simple case, you have an incident where criminals conspire to commit a terrorist attack together, and they communicate amongst one another using Gmail or Telegram or another email or messaging service. Now, even if all of the facts of the case, so the actual terrorist incident, all the persons participating in the plotting, all the victims are located in the same jurisdiction, the simple fact that these terrorists were using a messaging service that may be storing its data elsewhere, that may be run by a company that is headquartered or established elsewhere, creates a cross-border element in a case that otherwise is purely national in scope. And this cross-border element creates additional challenges for law enforcement and the judiciary because the tools that they work with were designed for their local jurisdiction. So as Greg was already saying, in these cases, the police and the judiciary have to rely on instruments for cooperation. Mutual legal assistance is the main one of these instruments, and our main destination country, speaking from the EU's perspective, for mutual legal assistance requests these days is the United States. And just under one of the conventions that we have, the EU-US Mutual Legal Assistance Convention, we have something like 4,000 requests from the EU member states for mutual legal assistance to the US. Now, these procedures take quite a long time. So on average, it takes about 10 months before a response can be provided. And that creates significant challenges for investigations. Now, granted, if there are situations such as terrorist cases or other incidents that require an emergency response, there is an emergency mechanism that is foreseen. But for every normal investigation, and that includes even those that Greg was highlighting on child sexual abuse, you are stuck with this 10-month deadline. Well, with this 10-month average, it can be faster. On occasion, it can also take a lot longer, so that's really the average. So this was identified as a major problem by all of the 28 EU member states, and they actually adopted council conclusions last summer, in June of last year, on jurisdiction in cyberspace, and asked the European Commission to take a look at whether there was a way to improve the existing situation. And they asked us to focus in particular on 3 specific areas. So first of all, they wanted us to look at what we can do to improve direct cooperation between law enforcement or the judiciary and service providers located in another member state or outside the EU, in particular in the US. As you may know, under US law, service providers based in the US can voluntarily cooperate with law enforcement from other states, including EU member states, for access to non-content data. So if law enforcement, as in the case that Greg was explaining, needs subscriber information to identify who has been behind a certain action or who is behind an account, that subscriber information under US law can be revealed also upon request by foreign law enforcement. And the same is true for metadata. That is not the case for content data, which has to be requested through mutual legal assistance at the moment. So that's the first channel that the member states asked us to improve. The second channel that they want us to look at is mutual legal assistance. So how can we bring that 10-month time frame down? What can we do to improve the way that the EU and the US in particular, but also other third country partners, work together on mutual legal assistance? And what can we do within the EU to speed up the mutual legal assistance procedures, which within the EU have just been replaced by the European investigation order for a large part? The third part, excuse me, that the member states asked us to look at is jurisdiction in cyberspace more generally. So what other investigative measures are relevant and what can be done to improve the framework for these measures? Now we, in response to this request, the Commission launched an expert process that included stakeholders from the member states, the judiciary, the ministries, law enforcement, from civil society, from industry, because of course the service providers are very much concerned by these measures, and then also from academia, to make sure that we have all the relevant expertise to be able to propose new ways forward. And that's what we've been doing over a large part of this past year. We've been trying to pull together, first of all, a problem definition on what exactly it is that we are talking about, and what the challenges are. And some of the main issues that we identified surround issues such as the transparency of the process, the lack of accountability of stakeholders in the process, depending on the legal framework that was being applied, the cumbersome bureaucracy that is behind some of these procedures that dates back to a time when such requests were few and far between, and where most cases were national in nature, and other issues such as the burden on the service providers to be able to respond to requests from foreign law enforcement, which often requires them to assess the legitimacy of a request that was made under foreign law, and hence requires them to gather or build expertise on how that foreign law works. And this is just a snapshot of the problem definition, but these problems we summarized in a December progress report to the stakeholders, which is published on our website. So if you go to the European Commission Home Affairs website, you will find a dedicated sub-site on electronic evidence, where everything I talk about today is explained in more detail, and where you will find all the relevant documents. After we established the problem definition, we worked a bit more on possible options to address these issues, and we're in fact reporting back to the ministers of justice of all the EU member states tomorrow, which is also why I am not participating in person, but would ask to stay here in Brussels just in case there's any last-minute hiccup. But our big process is coming to a conclusion tomorrow for the first phase of it. And in preparation for that, we published 2 weeks ago 2 papers that summarize the outcome of the expert process, and that I want to tell you briefly about now. You will also find them on the website. We have summarized a number of practical measures and also proposed some legislative options for improving the situation on access to electronic evidence across borders. So first of all, in terms of the practical measures, we looked at what we can do in particular to improve the cooperation between law enforcement and the service providers, because that's where the largest volume of requests is currently being shared. So if you look at the statistics, there's more than 100,000 requests going from law enforcement in all 28 EU member states to service providers just in the United States. And that shows the significance and the importance of this process, which again applies just to non-content data, so that's subscriber information and metadata. And for this process, we've proposed a number of options, a number of practical measures just to improve the way it works now. To improve the quality and the reliability of the process, we've proposed in particular to establish single points of contact on both sides. So to have within the member states a single point of contact that can provide expertise on the different policies of the service providers, and that can make sure that the requests that are outgoing from that member state meet certain quality standard. We've also proposed to the service providers to consider streamlining their policies, because as US legislation does not provide any particular guidance on what procedures should apply, each service provider has been left to come up with their own policies, and that creates significant challenges for law enforcement. We're trying to work with the member states on reducing and standardizing the number of forms that are used, And we've also made available €1 million funding for training for law enforcement and the judiciary on how to cooperate with service providers, and also on how to use the US mutual legal assistance procedures. We're also looking at establishing an online portal at EU level to provide information on the applicable rules and to facilitate the making of requests. And to improve the functioning of mutual legal assistance, so the European investigation order within the EU, we're also making available an online portal in a standardized form so that judiciary cooperation within the EU is fit for the modern age and is swift enough to respond to the needs. Now, perhaps even more interestingly for this discussion, we've also proposed a number of legislative options at the request of the ministers who've asked us to set out in parallel both the practical measures and the legislative possibilities. And the options that we've set out in the paper on the basis of the expert process fall into two different categories. So one part is designed for situations where you have an intermediary whom you can request to provide information. So a service provider is your counterpart. The second category applies in situations where there is no intermediary, where there is for example, a situation of an open search where somebody with a warrant is searching a device of a suspect that has data stored remotely, the so-called remote or direct access. Now, for the first category where we have an intermediary, we've proposed a number of different options that will be considered by the ministers tomorrow that relate to production requests or production orders. In particular, we've looked at possibilities to standardize the procedures that the member states apply when requesting access to information across borders. And we're looking at possibilities of doing this within the EU, beyond what is already possible under the European Investigation Order, and then also possibly beyond the EU, in particular when it comes to the US and non-content data. And we're looking both at mandatory forms and at voluntary forms, so that there would just be a standardized procedure without the resulting voluntary request being mandatory for the service provider. And on a direct or remote access, we have been looking with the experts at possibilities to mitigate the cross-border effects that access can have, and in particular on whether there are ways to standardize the safeguards and minimum conditions that the member states apply in choosing to use these measures, which at the moment are very different across the different EU member states. And we're also looking at the possibilities of introducing a notification solution, so that when law enforcement is enabled on the basis of usually a judicial order to take access to remotely stored data directly, that if law enforcement discovers where this data is stored, that the relevant country is notified. And these measures we're presenting to the Ministers of Justice tomorrow at the Justice and Home Affairs Council in Luxembourg for their further guidance on how to proceed. And if the ministers tell us that they want us to take forward these legislative options for further consideration, then we will look at developing legislative proposals for the EU in the months to come, and we'll continue our expert process. But so today and tomorrow are very exciting days for us. We'll have to see how things continue, and on that basis we may continue our work. And I'll stop here and
thank you very much.
Leave room for further discussion.
Thank you very much to Tanya. Yes, certainly can, yeah. I think we've got a question for you, Catherine.
Hi, excuse me that I'm intervening for the panel, into the panel flow, but I would like to ask Catherine for clarification. When you're talking about remote instruments, are you talking about remote forensic software and data capture for the purpose of interception, for example, and so on? Because it would be something a bit different than remote access to stored data. So basically the Commission is proposing both, or only remote access to stored data with possible notification of other countries? I mean, so it's not capture in real time, right? It's just remote access to data without production order. Am I right? Am I getting it right?
It is to be further defined. So the member states currently differ on what they permit, and one of the options that the experts established does not actually intervene in what member states currently do. It just says that if member states exercise the legal options available to them under their national law and discover in the process, because usually these are in situations where the location of the data cannot be established and where cooperation with another state is difficult or impossible. So if during the course of the investigation, under their national legal instruments, they do take access to such data, and if in the data they find clues as to where the data may be hosted, then one option that we have put forward for consideration is that at that point, the member state that is found to be possibly hosting the data should be involved by means of a notification procedure that could extend from a mere notification to a possibility for the member state to refuse the use of the data for evidentiary purposes in a later judicial proceeding. So at this point, the options are still open. We have not limited the scope of the possible measures and are awaiting the reaction of the ministers to this.
Okay, thank you. Detailed response, but I think it's important to see what the Commission and the legislators are doing in this field, just to get a base. And you probably will never get such a detailed briefing on what's going on there than you've just had now. So thank you very much, Catherine. Now, we'll go to the private industry side of the debate with Christian. So what are the service providers doing?
Thank you so much. So my name is Christian Borgren. I'm with the Computer and Communications Industry Association, and we represent the major international internet companies. And of course, this ambiguity is also a problem for our members who are international. I want to quickly touch upon the points we heard from Europol related to carrier-grade NATs, and then I will give some quick thoughts on the new paper and the discussions that the European ministers will be having tomorrow in relation to what we just heard from Catherine and the European Commission. So in terms of carrier-grade NATs, this is a temporary solution. It should only be a temporary solution as we all migrate from IPv4 to IPv6. Our members prefer a one-to-one allocation on IPv6 addresses, so one address to one user entity. And all our members, such as Google, Facebook, and Netflix, are all IPv6 enabled. So their traffic use IPv6 where that is possible to deliver to end users. So we obviously acknowledge that there are some problems with carrier-grade NATs for law enforcement. And I think it's very important to have the discussion, and I think you're having that also with broadband service providers, and maybe there are some of them here in the room who can explain a little bit some of the practical measures, some of the voluntary solutions, which could include logging and retention of source port information by these broadband providers, but of course, and also maybe limiting the number of users who will be using the same IP address. So we will welcome that discussion. But of course, the long-term solution is, of course, the rapid migration to IPv6. In terms of what we heard from the Commission here, so we have, as CCA, we've been taking part in this stakeholder discussions together also with civil society that the European Commission has been holding this year. And we welcome this dialogue. I think it's very important that all stakeholders, including civil society groups, are taking part in these discussions. And I think it's great that Catherine is actually talking here at EuroDIG. We have an empty chair, but at least she's participating remotely before she takes this to the member states. So I think that's a very good sign of engagement with stakeholders. And we are supportive of the European Commission's efforts to provide more justice in cyberspace, more clarity for users, more clarity for service providers, for internet companies, for law enforcement authorities. I think everybody would benefit from that more clarity. And of course, any law enforcement efforts must go hand in hand with safeguarding users' rights, mainly privacy. I think that's a given. We don't have to go too much into details, but I think that's sort of a baseline for this entire discussion, of course. In terms of what our companies are already doing, some of the practical measures we are already doing in terms of training for law enforcement authorities, it is in our interest that a law enforcement officer in Tallinn or in Romania is able to identify how to get into contact with Facebook or have a single point of contact, and that they use that they're able to craft high quality requests for information, so which we can actually evaluate, and if it's lawful, that we can respond to and to help them. So that's already something we are doing. In terms of the Commission's practical solutions, which they will also be presenting tomorrow to ministers, I think they all look very, very good. I take also the criticism that maybe some, especially US providers, maybe interpret a little bit differently the national laws, and maybe we should be looking a little bit and compare a little bit notes, so we give the same response back to law enforcement when they request data, that we have the same interpretation of the rules. And of course, especially the European framework is a bit of a jungle of different national rules, so a bit more clarification would be helpful there as well. In terms of standardization and having maybe one or two forms that law enforcement use, so it's always the same form, high quality form that we receive from law enforcement, I think that would be great to have maybe the European Commission, maybe with Europol, help provide that. More trainings for law enforcement officers, especially when it relates to US providers, because we have a different legal obligations on the US law that the US members have to adhere to. And then I think having one online portal with all the legal requirements created by the Commission, I think that would be helpful as well. So everybody's sort of on the same page. Now, on the legislative parts of the Commission proposal, because obviously all the practical solutions do not solve this legal jungle that we are faced with in Europe. So even though the practical solutions are great, we probably acknowledge that there is a need to look at this also from a legal perspective. I think the idea of trying to give law enforcement the opportunities to more directly require data from another EU member states is useful on a volunteer basis. That's especially important for US service providers, where we can only do this under if we are volunteer to do so. And an EU instrument which defines sort of common conditions and minimum safeguards, including notifications. I think that would be probably a good idea. I have one question. Tatiana was very, very quick in asking the first question, but that was also my question in terms of the direct access. I'm still a bit fussy on what that will include, so maybe Catherine can give a bit more clarity, or maybe we'll get that tomorrow in a press release after discussion with the member states. But I think that's where maybe I'm a little bit worried about sort of the user safeguards in terms of right to a fair trial, right to defense, privacy, data protection, ensuring a judicial redress for users. So I just want to make sure that that's fully thought out. I'm sure it is, but maybe Catherine can give you a bit more clarity on that. So to sum up, on carrier-grade NATs, this is a temporary solution. It should be a temporary solution. The real solution is actually migrating to IPv6, but it's great to have discussion directly with the broadband providers to find some interim solutions there, practical solutions. In terms of the Commission's work and their presentation tomorrow to ministers, I think it's great discussion to have, and all stakeholders have been involved, and it's great that all stakeholders, including civil society, is involved in these discussions. We welcome the practical measures that have been outlined, including those which requires a bit of work on our side. And then we have a few questions related to the direct access option, because it is only an option that ministers might go for or not. We want to make sure that, of course, it respects the safeguards for users, notably to privacy. Thank you.
Okay, thank you very much, Christian. Now we'll go to our last panelist, Constantinos from ISOC, to give your view on the discussion so far.
Thanks. So I think that it's safe to say from what we've heard so far that the environment is not surprisingly very complex and things are a little bit messy. And there are two issues here. We have the technical issue with carrier-grade NATs, and then of course there is the more legal issue that move into the MLATs. My name is Constantinos Samaras, and I work for an organization called the Internet Society. I am in the public policy team, and for those of you who are not very familiar with what we do, we do a lot of things, policy, technology, and development for the Internet. But one of our core functions is to provide the institutional home to the Internet Engineering Task Force. This is the organization that essentially creates the standards that make the internet and have made the internet what it is today, which brings me, of course, to the whole discussion about the carrier-grade NATs. The IETF created the IPv4 suite and suite of addresses, and it soon realized, of course, that there were issues with exhaustion. And it's by the time they realized that, they started working on IPv6. And for the past too many years, there are a lot of working groups and a lot of engineers that are working and are trying to make sure that IPv6 is deployed throughout the internet because of the problem that we're facing with IPv4 addresses. I think that both Greg and Christian alluded to the fact that IPv4 is meant to be a temporary solution. Unfortunately, the deployment of IPv6 has not been as fast as the engineers, the IETF, but also companies have hoped for. But we see more and more deployment happening. And I was actually very interested to hear that Belgium, for example, is the country that has deployed most of the IPv6 addresses. It actually, 80%, if I remember the number correctly, are of all Belgian services and companies are running with IPv6 addresses. So it's not an accident, for example, that there is this requirement when it comes to carrier-grade NATs, that they have imposed this requirement. And this is one of the incentives that governments can create in order to overcome this issue, because whether we like it or not, there are serious privacy considerations. There is the need for, and there is a balancing act here, because there is the very tangible and real need for law enforcement to be able and get access to those criminals and those, and identify who is behind the address, the specific address that is engaging in criminal activity. But then again, you cannot, there is the privacy component that says, if you have hundreds of people behind the same address, and you expose them to law enforcement just because you're trying to find one person, where do you draw the line? Which brings me sort of to this whole idea of, the MLATs and the cooperation that is happening. Okay, so first of all, the MLAT system is quite an old system. And as in any case, correct me if I'm wrong, I don't remember, but I think it was put together around about the 1940s. And it has proven to be very resilient, because actually it is the only process that ties together the laws on both the receiving and the request country, right? Making it legally robust at all levels. However, here comes the internet, and here comes technology, and here comes the pace of technology. And MLATs, they were already a little bit slow, but right now they're proving to be extremely slow. And this can have a huge detrimental effect on the way the requests are being processed, and it can rationalize the creation of new laws that require data, for example, to be held in a country. Thus, in a way, even contributing to the trend of data localization with all its harmful impacts. So the unique challenges for MLATs in the context of the internet, we can sort of summarize them in two big buckets. The first one is that in many, many cases, MLATs are based on the principle of dual criminality. So they impose a dual criminality requirement, which means that the conduct criminalized should be criminalized in both countries. Or they require the dual criminality standard to be met for some kinds of assistance. And this does not always happen when it comes to the internet, because you have too many jurisdictions occasionally involved. And then there is the complexity of managing electronic evidence requests. The MLAT process is time-consuming, and this makes it very difficult to capture electronic data effectively. And there are too many levels of bureaucratic process before the requested data is collected and then transmitted to the requesting authority. Now, until all that happens, electronic evidence can be lost, can be altered, can be tampered in the time between advancing the request and receiving the approval. So we have a system that used to work, it is a very good system that, because it's based on cooperation, and this cooperation needs to be happening between jurisdictions, law enforcement requests, but at the same time, it doesn't appear to be fit for purpose. So what do we do? I do not have the answer yet to that, but I would be really interested to hear from you how we can overcome the slowness and the time-consuming issue of MLATs, but not abandoning the whole rationale behind them. Thanks.
Okay, thank you very much, Constantinos. Now I'm going to just open it up to the floor and a bit of Q's and A's, and I'll start off because I have one question, and I'm going to say this as a ripe NCC person. Why aren't, and as this to Christian, why aren't the providers using V6? Why aren't they using V6?
You're talking about the broadband providers. So, I mean, we represent the internet companies, so I think I cannot respond on behalf of broadband providers. But I mean, there are a number of, to my understanding, there's a number of costs, number of different obstacles related to that. So, I don't know, maybe there's someone in the audience who will have a better view on that. But I think, the point is exactly, we need to all migrate to IPv6. Yeah. And then in the interim, if there are some challenges related to that, we should be discussing exactly as the example from Belgium, maybe there are some interim solutions that can be found.
Yeah. Good. I know we made it clear, the reason that we have, and I'll finish the carrier grade now. Now, the reason we have carrier grade now is because V4 doesn't speak to V6. That's why we have it. So there has to be some sort of box in the middle that allows the two to speak to each other. And there'll be a mathematical reason why they don't speak, which I know because V4 is that size and V6 is that size. So thanks very much to the panelists. Do we have, anyone has any, yes, we have already a question. Good, thank you.
Thank you.
So please stand up and
thank you.
Let me know who you are.
My name is Alexandru Frunză. I'm working for the Council of Europe Cybercrime Division. And I would also like to briefly inform you about the developments made at the Council of Europe with regard to cross-border collection of electronic evidence. So within the Council of Europe Cybercrime Division, the TCY, that is the Cybercrime Convention Committee that represents the 55 parties to the Budapest Convention that is international convention on cybercrime but also on electronic evidence. So electronic evidence gathered for each type of crime that you've mentioned before. So the TCY identified that it became more and more challenging for criminal justice authorities to obtain cross-border electronic evidence within their criminal justice investigation. So 2.5 years ago, the TCY established a working group named Cloud Evidence Group to look into these challenges and to propose some solutions to address these challenges. And the Cloud Evidence Group, after having comprehensive meetings with all important stakeholders on this topic, with data protection organization, with international organization, with private sector, with academia, at the end of 2016 proposed some solutions to address these legal challenges. And this solution went from practical and legal solution at domestic level to make mutual legal assistance more effective. Also comprised a draft guidance note. A draft guidance note is a common understanding of all parties to the Budapest Convention with regard to one article. And this article, Article 18.1b, regards the possibility of criminal justice authorities of parties to the Budapest Convention to request data, subscriber information only, from a service provider which is not established in that country, but is offering the services towards that country. And in February, this guidance note was adopted, and once implemented in the domestic law of the parties, will give the possibility for criminal justice authorities to ask subscriber information from service providers which are not established in the territory of that country, but direct services towards that country. Another proposed solution for TCY was the differentiating of rules and procedure regarding subscriber information, traffic data, and content data. So to make it possible for criminal justice authorities to obtain subscriber information more easily than obtaining traffic data or content data. And the last solution proposed by the Cloud Evidence Group, and I may say that these are not alternative solutions, but are cumulative solutions which can be taken gradually, is the negotiation and future adoption of an additional protocol to the Budapest Convention to address all these mentioned challenges. And since today and until the 9th of June, the TCY will hold its plenary and will discuss the terms of reference with regard to this additional protocol. So the Council of Europe is working towards identifying solution, and we try to address this solution, if feasible, with the help of an additional protocol to the Budapest Convention. Thank you.
Thank you. Any comments on that, or any up? Tanya?
Thank you very
then,
much.
Then sir behind us.
I actually have one question and a couple of interventions. My first question, after listening to Alexandru from Council of Europe, is European Commission and Council of Europe, are you anyhow coordinating your efforts? Do you have channels? I mean, it looks to me like sometimes you're duplicating the efforts, and I understand that Budapest Convention is like much more than European Commission. It's outside of the region. It's really like striving to become a global solution and a golden standard, and in a way it is. So my question to both of you, are you communicating anyhow? My second, how to say, rather intervention or musing about something, about legal solutions, because when I hear about legal solutions, I'm just wondering if European Commission or anyone will propose legal solutions, how they are going to be sustained and who is going to watch implementation, because if I think about gathering evidence, like for example, and I look at the EU Convention or EU document on mutual legal assistance from 2000, for example, Article 18 and 19, there is a provision on direct data transfer in interception of communications, which would apply also to digital investigations, so IP interception. And it exists for 16 years already, but there are only 2 countries whom I know who actually can directly transfer data, because while this norm wonderfully exists on paper and has been existing for 16 years, there is no technical implementation and no standards on this. So Council of Europe or European Commission for that matter, if you propose any legislative changes, are you really going to also push for also technical implementation of this? So will you have next steps, or would it be just recommendation? Thank you very much.
Okay. Catherine, do you want to respond to that?
Yes, I'd be happy to. Tanya, I think these are extremely relevant points, and thank you for raising them. On the first part of about the coordination between the work of the Council of Europe and the European Commission, I mean, as you know, the European Union is firmly behind the Budapest Convention, and in fact, most of the funding that we dedicate to capacity building is channeled through the Council of Europe and has the aim of ensuring that the Budapest Convention is the global gold standard for cybercrime legislation, and is, if not adopted by all countries, at least taken as a model by those who consider that those principles can also apply in their frameworks. So in practice, what we have done is that we are actively following the work of the Cloud Evidence Group, and have had an observer from the Commission, from our e-evidence task force, participate in the meetings. My colleague Csaba is now at the Council of Europe plenary of the Budapest Convention, which we attend every time. And we have also had a representative from the TCY, so from the Bureau, in all of the expert meetings that we held on the discussions on access, cross-border access to evidence. And in fact, the discussion, just as by way of historical reference, the discussion on cross-border access to evidence was launched by the Netherlands, which at the time also held the chairmanship of the TCY. At the Council of Europe, in the hopes that coming to a solid agreement within the EU could also help catalyze progress within the larger group of the Council of Europe member states by having a solution that's at least regionally agreed. But the second reason for why we are working a bit in parallel within the European Union is that within the European Union we have closer possibilities for cooperation that don't extend across all the Council of Europe participants by mere virtue of having commonly agreed standards, for example, on the protection of victims, on the protection of the rights of the defense, and other such issues that have been agreed between all the EU member states and that allow us an even closer cooperation than is sometimes possible with all the third states. And so we're hoping that we can come to coordinated and not necessarily overlapping, but complementary solutions within the EU and then in the broader context of the Council of Europe. In one part that I didn't go into much detail is that, of course, for any solutions that go beyond the EU, the ideal basis would be bilateral or multilateral agreements, including a possible protocol to the Budapest Convention to make sure that on transporter access to evidence, we have a framework that works both within the EU and with all the partner countries that come together in the framework of the Budapest Convention. Yes, so that's in terms of the cooperation on the convention. And Tanya, just remind me of your second question, sorry.
Yeah, the second question, if you advising to make any legislative change, how to ensure that they don't exist on paper only and just look wonderful?
Yes, so what we're trying, I mean, obviously the MLA convention is a convention, so that was the member states deciding. If the member states were to agree to put forward, for us to put forward legislative proposals, then that would become EU legislation. So it's on a bit of a different level. And we're also seeing a different level of motivation, especially among the member states. So as you may know, the European Investigation Order was also designed on the basis of the member states' initiative. So we're seeing a lot more interest also from the member states in having workable solutions. And while that may not be of the same relevance to each and every member state, for the largest part, we do see an interest in all the member states in having a new solution and having existing solutions that function better. And as I said before, at the moment, we do see requests from all 28 EU member states to service providers located abroad, and we had pretty much universal complaints about the way the current system functions. And maybe just also to address the comment that Constantinos made on the need to improve mutual legal assistance tools, I cannot agree more. And that's part of the work that we've already been doing, because a lot of that comes down to practical measures. So people need to understand the different requirements of the two legal systems that have to be respected. That's why we're providing the training. But also in terms of improving the speed of the procedure, the US has taken some important measures to make things more efficient. So they have created a little task force of their own within the office that deals with mutual legal assistance requests to focus on electronic evidence in particular and to work on improving the speed of response, in particular to those electronic evidence requests. Because as Konstantinos rightly pointed out, the data might just disappear in the meantime, especially if there was no freezing request made. And the US has also adopted legislation to enable the Department of Justice officials from that office to basically plead the cases in DC, regardless of where in the country the electronic evidence is being requested from, which is a change in procedure from the previous system and enables them, basically the person who is dealing with the case in the Office of International Affairs, to deal with the matter also in front of the judge, to my understanding. So I fully agree there's more to be done to make mutual legal assistance more efficient, and we're definitely not looking at replacing it. We're looking at complementing it with additional measures for situations where the full administrative procedure of mutual legal assistance is not deemed to be necessary by both sides.
Okay, thanks very much, Catherine. Gentleman in the blue.
Hello, I have a bit of technical question. My name is Raul. I am a student and also practice some digital forensics. I was listening very carefully to this a bit eye-opening network address translation issue. And I was wondering if on technical side, a better solution or option would be look into NetFlow or logging of, let's say, layer 3 devices in the networks, or whatever equivalent is in the mobile networks, where network address translating takes place, and enable logging of public IPv4 addresses to whatever private IP addresses are inside those mobile networks. Also, even though I do not, I have no knowledge about specifics about mobile networks, I've seen that in my own smartphone, both private and public IP addresses stay the same, like, if not always, for a very long time. So my second idea or thought would be, if it is possible legally to track those users for extended time, it would be also possible to identify it. I don't know why the private IP address stands the same or stays the same for a long time. Is it because a smartphone is never switched off and DHCP lease gets renewed all the time for the same IP address? But would either of those two be a little better solution than limiting the amount of the number of private IP addresses connected to the network?
Okay.
Thank you.
I was hoping someone would answer that.
Thank you very much for your question. There are many alternative technical solutions to improve the situations. One of those is the one you've just described. You can also ask the content providers, the platforms, to log more information. If all the websites and the platforms were to log source port number that are, once the connection, the TCP/IP connection is made, then you would be able to turn back to the internet access providers with an IP address, a source port number, a timestamp, and then you can discriminate between the many users of the same IP addresses. But we're talking about more logging, we're talking about more cost, and we're talking about solutions to a problem which is supposed to be temporary. So I don't want to find a solution which increases the logging, plus is just perpetuating a situation which is bad. We need to find solutions that are providing incentive to the internet access providers to switch to the new technology, to switch to modernity, to stop using v4. So the main argument for the internet access providers to say, oh, we still need to use CGN is because there is a huge legacy infrastructure that is still using v4. Some phones are only available on v4. Some websites are still only available on v4. And the internet access providers don't want to take the risk to switch to technology completely and have their customers only able to access some parts of the web that are only v6 compatible. So the Belgium solution of voluntarily limiting the number of users behind each IPv4 address is good, because ISPs and internet access providers make the strategic decision which will change their environments, their commercial environment. It is becoming less financially interesting to spend money on CGN boxes provided by Cisco and Juniper than on investing in upgrading your softwares and your hardware to allow v6, because you don't make as much money out of an IPv4 if you only have 4 people behind rather than if you have 200 customers. So you see, we need to find a market-friendly solutions. And it's very interesting. I went around Belgium. I spoke to the telecom regulator. I spoke to the police. I spoke to the prosecutor, the government. And one of the unintended consequences of that voluntary agreement established in 2012 is that nowadays Belgium has the highest IPv6 adoption rates in the world. So mechanically, that voluntary agreement has led to a situation where Belgium is leading the trend. And it's 49% of V6 native in Belgium. So you can say, and some providers are saying, Belgium is a specific case, it's a small country. I don't buy this. It's just there was a voluntary decision made by the government in conjunction with the industry to move on together to a different solution. And I think we should do the same at European level. And we need to put the pressure on the content providers to give their content available to V6 and on the internet access providers to provide IPv6 connectivity natives. If nobody raised the issue, then they are in their comfort zone. There is a past dependency issue where they are used to, as a company, to spend every year money on CGN boxes. They grow the network, so they buy new technologies, and everything's fine. All their applications are working. This is okay. No, it's not okay. So we need to put a little bit of pressure so that they feel the heat, and then we find a solution which give incentives to move to V6.
Okay, I think we've got a remote, or do you want to respond?
Very, very quickly, just to go back to what Gregory was saying about IPv6 adoption, we recently released a report that you might want to read and be interested in, and the report identifies that although there is an increase in the adoption of IPv6, enterprises are still reluctant and companies are still reluctant to go and adopt full IPv6 suite of addresses. And the report makes a very clear point that there are only benefits in actually transitioning to IPv6, and this needs to happen. The sooner the better, because at some point it will inevitably happen. There are no more IPv4 addresses. It's as simple as that. So, and I know that you are, you're sort of disagreeing with that, but there is, the IETF has made a clear point that all technologies, and especially as we move to the Internet of Things, IPv6 addresses need to be adopted in order to move things forward.
If I may, very briefly, it is not going to happen mechanically. CGN technologies have become so advanced that for some internet access providers, it is a substitute for V6. There is no technical reason for some big internet access providers to switch to V6 at all. The carrier-grade NAT is, they're just sitting on a pile of V4. They can mutualize. Everything is working fine. Honestly, there's no incentive, really, for many, many of the providers. And of course, I've got many arguments why CGN is not good. It's not good for security. It's not good for privacy. It's not good for many other things. We need to move to V6.
And the reason, just before we go to the remote thing, the reason that this is an interesting topic regarding e-evidence is because if law enforcement or anyone who's trying to attribute an individual to criminal activity can't do it, then they can't get the evidence. Because that's the crux of the issue here. I think we've got a remote question.
Dick, I'm actually sorry to disappoint. This is just, I want to make a point personally.
Oh,
yeah. There's no remote interaction going on, but of course we have a wonderful speaker. So I'll just get up to speak. My name is Michael Ogia, and I do a lot of work in the internet governance community. One of the things that I had been doing for 2 years is being involved with the IPv6 Best Practice Forum through the Internet Governance Forum. We came up with a lot of really interesting stories from around the world when it comes to IPv6 deployment. I really want to kind of follow up and add to what Greg was saying about, and what you had mentioned about carrier-grade NAT. I think it's very much a double-edged sword. And in terms of having started using it from the get-go to where we are now, for many of the reasons, Greg, that you had just mentioned, for instance, that it's often become a replacement for IPv6 or something along those lines. I want to share with you an anecdote that a friend of mine who works for a large German bank. He works in the technology department, and I was asking him once to contribute to this research that we were doing about IPv6. And he said, and I quote, "The internet will be fine without IPv6." This is a technologist. He's working in a large public institution or a private institution. The point is, if he thinks that, then I'm really worried about what other people think as well, because this is clearly something that needs to be implemented if we're going to ensure that the internet continues to function in the future. With that said, my mind is a bit blown about something. I never thought about the idea about having, for instance, law enforcement agencies or in those kinds of stakeholders to advocate for IPv6. I mean, whenever we're doing so within the technical community, I've never thought about that kind of cooperation, that kind of collaboration, that kind of multi-stakeholder pushing for it. So I think the more that we could encourage that, I think the more that we would all benefit from IPv6 adoption.
Isn't EuroDIG a wonderful thing, yeah?
Really, no, really, this is exemplifies
Getting all
it,
these different
yeah.
stakeholders together, and that's the whole idea of it. And law enforcement, it's not just law enforcement, we keep saying law enforcement, but law enforcement and governments are more involved in this bottom-up multi-stakeholder environment all over the world in many different fora, the IETF, the ICANN, in the RIPE, in the IRR communities, so they're paying particular interest to this. Do we have any other questions? Please, someone ask a question, otherwise I'll pick someone out. Yes, well done, sir.
Thank you very much. My name is Georgi. I work as a project manager at the Council of Europe as well, but at the Bucharest office, which is actually managing the projects with generous funding from the EU when it comes to the Eastern Partnership and the other parts of the world. And those are actually centered on the topics of international cooperation, public-private cooperation. So it seems that there is less readiness when it comes to the private sector to do the training for the law enforcement for the countries that are outside the EU. And I'm speaking specifically about the law enforcement of the Eastern Partnership because we addressed this issue many times to multinational service providers, and we've always got denials and refusals to actually come to events that we would prearrange for them in terms of participants and everything. So this is something to look into. But also the second point very quickly with regard to the mutual legal assistance, because it need not to be a very inefficient process, because in one of the countries of the Eastern Partnership, which is Georgia, the MLA requests are processed between 1 to 2 months, which is insanely fast in terms of the mutual legal assistance. And I'm talking about non-urgent requests that are dealt with a triage system to single out the priority requests. So they are dealt with in a month, if the case is particularly complicated within 2 months. So there is still the life in that old concept, the left in the 1940s, just you have to implement it properly.
Okay. Thank you very much. I'm just looking at the time. We've got 15 minutes, so what I would like to do, I think, Nina, you may have an intervention, then we'll just go quickly around the panel to sum up, and then the report in the last 2-3 minutes. Nina?
A question rather than a comment, but I was wondering, from all we've heard so far, maybe a question to all of you. Do you believe that the existing mechanisms and legal frameworks that we have are sufficient, or is there really a need for something new? Because I understand the existing frameworks, for instance, there's problems with admissibility of e-evidence in other countries, or some countries even forbid that service providers give information to other countries. So my question is there any room for improvement to what exists, or is there really a need for new legislation?
Okay, so who wants to take that one?
Maybe I can start.
Christian, please.
I think, these are it's a very complex discussion, both relates to carrier-grade NATs, but also just in terms of e-evidence and how countries should work together with in very complex environments. And, we are actually in Europe first in class, I think, both what's happening at EU level, but also at Council of Europe. Council of Europe is actually much bigger than Europe. It's much more global and involves much more countries, including outside of the EU membership. So I think having these discussions could actually provide solutions for other countries around the world, where a country might be, say, we want that data, so you better store that data in our country, or we will just find a way to hack our way into that data. And we don't care if a company has to break the country, the laws of another country, because our country is the one that abides. So I think what the EU is trying to do, what's happening in Council of Europe is actually really applaudable. I think to Michael's point earlier, IPv4 is just fine. I don't think so. You see Windsurf, you see the people who invented the IP system decades ago saying, sorry, it's not working, we're running out of IP. The solution is to go to, as quickly as possible, to IPv6. And, so Windsurf now works for Google. They have already done the transition. I think the bottleneck is with the broadband providers who needs to, find some temporary solutions, but not spend all the time doing that, so they have sort of a too much time to just do very little with the real problem, which is the migration.
Anyone else want to comment? Or
Very briefly on MLAT. From a law enforcement perspective, in 2017, the future looks very bright. If you look back 2-3 years ago, we felt that we were really alone, nobody really would listen to, and when we were complaining about difficulty to investigate crime online, people would say, oh, solve the MLAT problem, but nobody really cared. Now we've got a massive initiative from the Council of Europe, which is bearing fruits. We've got the Commission on the back. I've just seen Bertrand Lachapelle coming in. We've got initiatives such as the Internet and Jurisdiction Project. So we are moving in the right directions. We have many different alternatives. We need to find a compromise and move forward. So that's good. On the carrier-grade NAT aspect, I think so far the discussion has been really hijacked by the technologists and by the network operators and the rest. And from a technological perspective, CGN is solving the IPv4 depletion problem. So you can live with it. But we have to make the public policy argument that CGNs are bad for society. It is bad for privacy, it is bad for security, it is bad for innovation. Maybe you don't know, but many apps are breaking behind CGN. So if you're an innovative person, you come up with an app, a banking app, for instance, and you need the port and the IP address for authentication, it will break behind a CGN. And there's no standard CGN, so every ISP is using a different types of CGN. So you will go and see ISP A and say, my app doesn't work. Okay, let's do a software solution. It costs money, you pay for it, you come up. Your customers move to a different country, change providers, it breaks again. So from an innovation perspective, it's really bad. Of course, Netflix, global, they can come up with solutions with most of the ISPs because video streaming is also breaking behind CGN. Skype is also breaking behind CGN. Nobody talks about it. You find technical solutions, but that's costly. And if you're a small innovation person with a new app, then you don't have the money to find solutions for each of those. So I think we need to really make the public policy arguments, and we need to move. I'm happy with voluntary solution, but if it doesn't work, we also have to look into regulation.
Okay, thank you. And just on what we're talking about, the different forums, there is a proposal to have this type of discussion at the IGF in Geneva in December. So if people go in there, hopefully, there will be a similar type of discussion. Konstantinos.
Just very briefly, answering directly to your question, I am a little bit skeptical with creating something new. I don't think that we have actually exhausted the tools that we have in order to be able and address those complex issues. Having said that, the issue of jurisdiction, I remember discussing it 20 years ago. And Bertrand, you've mentioned Bertrand. Bertrand is still discussing it, and he can certainly attest to the challenges that are out there because, jurisdictional challenges was always the case. Now with the internet, where you have multiple jurisdictions, imagine that the level of complexity is increasing. I agree totally with you. Yes, there are cases where the MLATs are working. To me, the way that I see them, these are exceptions, but this indicates that the system actually is able to provide answers and that the tools are there to provide answers. It's just that we need to update our understanding and our requirements because in particular when it comes to e-evidence, there are issues that need to be dealt in a very fast manner. And occasionally they get stuck into the bureaucracy of the system, and there is whereas there is this willingness for cooperation, it doesn't go as far as to provide those answers that law enforcement agencies need in order to process the cases. For IPv6, I think that I've made the point that, as far as we're concerned, there is no other option than companies need to move, and actually they need to lead by example, because at this stage, the suite is in place for the past 20 years. I was actually reading the report that we've released, is in place for 20 years. And by now, we should have had literally almost full adoption and transition to IPv6. So companies, and the big companies, because there are costs associated with it, need to lead by example. And they need to be able and say that this is, because we need to deploy IPv6, it is more secure, it is more efficient, and it actually will solve a lot of the problems that we hear coming from the law enforcement and other governmental agencies.
Okay. Catherine, I don't know if you can see me, so I can't do my cut it. So, so a couple of minutes, please, just to sum up before we go to Tanya.
Right. No, I think the question that Nina posed is actually extremely relevant. I mean, to what extent do we need to move to a new system if we already have rules that may benefit from improvement? I think mutual legal assistance is really here to stay and will remain relevant for a number of situations where it is appropriate. However, countries have decided that they do not want mutual legal assistance requests to them for everything. So, very practical example, the US is actively encouraging other countries to use channels beyond mutual legal assistance for data that they consider to be less privacy invasive, such as, in particular, subscriber information and traffic data. And the fact of the matter is, at the moment, that while they encourage this use, there is no formalized channel to deal with this, with the requests that come outside of the conventional mutual legal assistance process. And that, from the point of view of the rights of the defense of criminal procedure, in the minds of the experts of our process, creates certain challenges, including on the accountability of the actors that participate in the process, on the transparency of the process. And that's why, at least in our expert process, the experts were very much in favor, and that goes for all the stakeholders. So you've heard Christian say it, this opinion is shared by the judiciary and practitioners, by academia, and by civil society, that it would be beneficial to come to a reliable legislative solution on these issues. Now, remains to be seen what the ministers think of this, but what we are seeing already is that a number of countries are developing unilateral solutions, and this debate is getting more heated as the different approaches to this topic multiply, and that obviously doesn't facilitate things. So, I mean, I think that on the basis of this process, it would be, at least on the basis of the expert conclusions, it's difficult to say that we can just move on with the existing system without any legislative modifications. Okay. And that's my summary.
Thanks. As you can see, this topic, we could go on for days and days and days, and we're only just scratching the surface of this particular, and we haven't even gone into the big encryption debate and many other challenges that governments and law enforcement have in keeping the public safe, because all we're talking about is keeping the public safe. And at the recent events in my hometown, you can see why that's really important. So before Tanya wraps up, can we just give everyone a nice clap for coming all the way here? Well done, people. And Tanya? Oh no, please.
Thank you very much. I'm literally trying to shut myself up because I wanted to make a remark about mutual legal assistance before wrapping up, but I will. Yeah. Sorry? No way, no way?
No way, no way.
Yeah. So, as a reporter for this session, I would like to provide a few conclusions as a wrap-up following this discussion. So the first one is practical ad hoc solutions to the digital evidence problem will not solve legal Wild West. We need structured solution which can include modifying existing legal standards. The second conclusion is the possible legal solutions can involve, along with changing the legislation, standardization of forms, capacity building and training, establishment of channels for facilitating assistance requests, like online portals. The structured solution, while harmonizing procedures in different countries and facilitating requests, should respect human rights, have safeguards, and be transparent. It is important that all stakeholders take part in the discussion on the solutions development. And the last one, there is a need for capacity building not only for law enforcement to process requests and criminal investigations, but also for both law enforcement and intermediaries to create a common understanding how the requests are to be sent and processed in a cross-border environment.
Okay. Thank you very much. And by my watch, we're 2 minutes early, so please, thank you very much for coming and attending. These guys will be around for the rest of the day. I will be as well, so please come and speak to us if you want to have a bit more information. Obviously, it'd be hard for Catherine, but I can give you her personal phone number if you want to phone her direct. And I'm sure she would be lovely to speak to you. So unless anyone's got anything to say, we can all go for a nice lunch, and thank you very much for coming. Thank you.